The lemon law in California protects consumers who have purchased defective products and thus gotten a bad deal that is still covered by the manufacturer's warranty. The Song-Beverly Consumer Warranty Act, or California Civil Code Section 1790-1795.5, gives consumers the right to sue manufacturers if they fail to fix or replace a lemon. In today's video, we'll discuss whether you're entitled to damages for a warranty breach. But first, a warm welcome back to the channel from Alpha Law Firm. Please subscribe and activate notifications if you want to be notified of every new upload. Home appliances, electronics, RVs, boats, musical instruments, air conditioners, and other consumer products are all covered by the lemon law. If you bought something and there's a major problem with it and it's covered by a warranty, the lemon law guarantees customers a reasonable number of methods to fix the problem. What is appropriate varies depending on the severity of the problem. The fewer repair attempts and time allotted, the better. Finally, if a manufacturer fails to correct a fault within a reasonable time frame, consumers are entitled to a refund or replacement. Why do lawyers need to get involved? Isn't the law straightforward? It's a little more complicated than it appears. Manufacturers frequently argue about whether the product is defective to begin with. When they admit there is a problem, they argue over how serious it is or say it has been resolved. They claim that they have not yet been given a reasonable opportunity to correct the flaw, even when there is no doubt that there is a significant issue. Lemon law lawsuits have been accumulating for decades. The legal analysis is not black and white. There is plenty of room for lawyers on both sides to make arguments. Many of these cases have gone to trial and are still being litigated, necessitating the need for lawyers. However, if you have data on your side, you may not require a lawyer. Let's imagine your brand new car had 6 significant transmission-related issues in the first 6 months and was out of commission for more than 90 days. However, most situations are not as easy as this one. Even if your cause is compelling, the manufacturer, usually a large corporation, rarely agrees. Manufacturers lack the financial motivation to give in to consumers without the involvement of lawyers, especially when it comes to pricey goods like cars and trucks. Most people who try to achieve it on their own will be buried by their seemingly limitless resources. Consumer protection regulations are in place for a purpose. And if you have a compelling case, you must battle to ensure that these behemoth corporations do not get away with exploiting customers. In the end, you'll have to file a lawsuit to get a refund or a replacement for your lemon. But how is the average customer meant to pay a lawsuit against a multi-billion-dollar corporation? Fortunately, the lemon law stipulates that if you win your claim, the manufacturer must pay your attorney's fees and charges. That means you may hire a lawyer and fight your case without having a huge bill hanging over your head. Is your case now solid and worthwhile? In most circumstances, the essential question is whether you provided the manufacturer a fair number of repair attempts, and they failed to correct the problem. That is, until you've given the manufacturer a chance to fix the flaw and they've failed to do so within a reasonable time frame. A damaged product isn't a lemon and thus not covered by the lemon law. The more serious the issue, the fewer attempts at correction are made. For example, if your new vehicle's brakes are faulty and potentially dangerous, and they're still malfunctioning after 2 visits to the shop for repairs, that should be sufficient evidence to file a lawsuit. However, if you're dealing with something less serious, you'll need to visit the business more frequently. When less dangerous problems arise, at least 4 visits to the shop, or a total of 30 days out of service must be proved. The repair bills recording the dates your consumer goods were serviced and the work that was accomplished are the most crucial pieces of proof, at least at first. However, in the meantime, consider the following questions. If you answered yes to all of the questions, you most likely have a lemon law claim. If you respond no to any of the questions, you aren't always out of luck. You could, for example, have a separate lemon law claim for breach of an implied guarantee. Now, what voids a car warranty? Please keep on watching to learn more about that. Also, please hit the thumbs up button and feel free to ask for clarifications in the comments down below. We'll be happy to assist you. Buyers, like dealers, are responsible for upholding their end of a car warranty. If the customer fails to keep their half of the bargain, the guarantee may be void. You must avoid any acts that could invalidate your warranty. It's also critical that you understand other scenarios that could lead to a void auto warranty, so that you know your legal rights. The following are some examples of things that can void an automobile warranty. Misuse of the vehicle is the first. This is a broad topic that can be viewed in a variety of ways. Misusing a vehicle, on the other hand, generally entails using it for a legal purpose, such as street racing or for any purpose for which it is not designed. Salvage title is one thing that could lead to a warranty breach. The manufacturer's guarantee is void if your vehicle was previously involved in a catastrophic accident and was declared a total loss or granted a salvage title as a result. If you're buying a used car, find out about its past and whether it's been in any accidents. A full history report should come with a certified pre-owned vehicle, but an independent seller's used vehicle may not. Failure to provide appropriate service is another. Many warranties require car owners to do particular maintenance at predetermined intervals to maintain their warranty. Failure to bring a vehicle in on time or to perform required maintenance, such as failing to get an oil change, might result in your warranty being voided. Warranty breaches can also be caused by modifications in aftermarket parts. While having an aftermarket modification or part does not immediately void your warranty, contrary to what some dealers may try to convince you, if the aftermarket part or modification causes another part to fail, the warranty on repairs for that part may be voided. An altered odometer is another cause. When a dealer is unable to verify the mileage in your car because of an odometer that has been manipulated or tampered with, your warranty is usually voided. A dealer might look into the vehicle's history to discover if there are any discrepancies in mileage reports that could indicate odometer manipulation. Environmental damage can potentially result in a warranty breach. Your warranty may be canceled if the damage is caused by environmental conditions such as flooding, fires, or earthquakes. Remember that consumer goods include implied or non-written warranties, the most frequent of which is the implied assurance that the things are merchantable. A claim for violation of the implied warranty of merchantability is distinct from a breach of explicit warranty claims and falls under the scope of lemon law. Most importantly, you do not need to show that the manufacturer offered multiple repair options. There would be no repairs if your brand new vehicle abruptly burst into flames and was destroyed. Is it true that you don't have a lemon law claim because you haven't tried to repair it? No, that would be absurd. Under a violation of the implied guarantee approach, you would have a very solid lemon law case. Finally, the best way to assess whether you have a valid case is to contact a lawyer, who should not charge you anything for a session. One of the most appealing aspects of consumer cases is this. So if you bought a defective product and the manufacturer or dealer won't correct it in a fair amount of time, you have nothing to lose by hiring a lawyer to represent you. That's it for today's video. Remember that this is not legal advice and does not constitute attorney-client relationship. Call now to learn more. 323-51-LEMON, 53666. Don't forget to hit the subscribe button and do not forget to turn on the notifications to be notified of every upload. This is Alpha Law Firm, and we will see you in our next video.